Good morning. I'm Sally Ryder, the director of the Rehnquist Center, and on behalf of the Center and the James E. Rogers College of Law, I'd like to welcome you to the second Rehnquist Center lecture. The inaugural lecture was given by Justice Sandra Day O'Connor in February of 2007, and we are honored that Secretary of Homeland Security Michael Chertoff is here to deliver the second lecture. Please make sure that you have your cell phones off, any other electronic equipment. Now's the time to do that. The Rehnquist Center is a nonpartisan academic center established at the College of Law in 2006, and its focus is structural constitutional issues such as the balance of powers between the state and federal governments and sovereigns more generally, and the role of an independent judiciary in our national government. The Center's board, and I think we have two members here today, Dean Tony Massaro and Mike Meehan, and Judge Earl Carroll was going to be here, but I don't think he could make it. But the board last February decided to ask Secretary Chertoff to be our second speaker because of his unique background in the judiciary and the executive branch. Secretary Chertoff is a 1978 Harvard Law School graduate who served as a law clerk for Supreme Court Justice William Brennan, Jr. during the 1979 term. From June 2003 to February 2005, he served as a judge on the U.S. Court of Appeals for the Third Circuit. Prior to that time, Secretary Chertoff was the Assistant Attorney General for the Criminal Division at the U.S. Department of Justice, a partner in the Latham and Watkins law firm, along with another Rehnquist Center board member, Maureen Mahoney, special counsel for the U.S. Senate's Whitewater Committee, and for more than a decade, he served as a federal prosecutor in New Jersey, where he prosecuted political corruption, organized crime, and corporate fraud cases. Secretary Chertoff was sworn in as the second Secretary of Homeland Security in February 2005. With that background, he's in a unique position to give us a practical perspective on the structural constitutional issues that are the Rehnquist Center's focus. And when the Secretary concludes his remarks, he's going to take a few questions, and we have students in the audience with microphones so that everyone can hear the questions. And when he leaves, we need everyone to remain seated until the Secretary is out of the room and across the courtyard. So please join me in welcoming Secretary Michael Chertoff.
Well, thank you, Sally. It's really an honor to be here at the Rehnquist Center, first of all, because Chief Justice Rehnquist was obviously a giant in the law. And when I was clerking, he was then Associate Justice Rehnquist. And actually, Maureen Mahoney was clerking for Justice Rehnquist at that point. We began our friendship at that stage. And it's also an honor because I'm following Justice O'Connor, me, a former lowly Court of Appeals judge. So it really is elevating me to very, very good company. I also think it's a great location to talk about some of the emerging issues of structural constitutional law, both domestically and internationally. I think that we are entering a period of enormous change in legal doctrine, a period when we're going to be rethinking and revisiting some of the principles that we've accepted for a long period of time, because what we are seeing is that the world does not neatly fit itself into the legal categories that we've been accustomed to. I don't think it's a new phenomenon to have to revisit our legal thinking. I think periodically we enter ages of societal change which result in our need to start to reconsider whether our legal framework is appropriately adapted to modern circumstances. What's particularly interesting to me, though, and it's why I'm going to focus on the issue of the rule of law, not the rule of lawyers, is what the role of a judge is in this process of dealing with modern challenges to existing legal doctrines, and what the responsibility of a judge is in exercising that role. Because I think we often talk about the rule of law and the importance of judicial independence, but we don't necessarily talk about the fact that the judge has a responsibility to play if the judge is going to uphold the rule of law. In other words, it's not a one-sided bargain that the judge has all the power and all the authority and no responsibility. So that's really a part of what I want to talk about today. Actually, Chief Justice Rehnquist himself well understood this issue. In his own words, in one of his opinions, he stated that the Constitution protects judicial independence not to benefit judges, but to protect the rule of law. And I think that was a recognition of the fact that the rule of law and judicial independence puts the judge in the position of having a trust, an obligation to society. And how the judge exercises that trust is a huge determinant of whether the rule of law will in fact be vindicated. We all know that judges are human beings, and because of human nature, sometimes there is a temptation for a judge to begin to believe that his power comes from his personal qualities rather than from his institutional position. And for that reason, some of our greatest judges have understood the importance of making sure they have a firmly embedded concept of their own role and their own responsibility. And it's particularly because of the ease with which we can become persuaded that our own opinions have some independent justification, that a judge always has to be on guard to police the boundaries of his or her own activities to make sure that he or she is staying within proper judicial bounds. This is, of course, what Chief Justice Rehnquist's current successor, Chief Justice Roberts, referred to during his confirmation hearings as judicial modesty. And actually, I think that's a great term, because when I was in school, we used to talk about judicial restraint as the idea that judges had to restrain themselves in getting too active in promoting their own personal views. But in some ways, that's a little less precise than judicial modesty, because restraint tends to be viewed as a question of doctrine. Does a judge believe that certain provisions of the Constitution give him or her authority to be energetic, or should the judge be very cautious and incremental? Judicial modesty focuses more upon the judge's own intellectual processes, the consciousness of the fact that putting on a robe does not necessarily imbue the judge with supreme wisdom or supreme competence, that a judge has to be conscious of his or her own limitations, professional limitations and limitations of experience, when a judge decides to adjudicate, particularly in areas that usually fall within the competence of executive or legislative branches. So I'm going to talk a little bit about judicial modesty, both as it applies to us here in this new legal world that I think we're facing. But also I want to talk about it from an international standpoint, because I think it's in the international arena that the question of the proper role of the judge and the lawyer has, to my mind, become the most acute issue in the last 10 years. And it's an area where, frankly, Americans have not been major participants in the discussion. And I believe because of the increasing significance of international law for how we interact with our allies and even our adversaries overseas, I think it's important for Americans to engage in this question internationally, because international law is increasingly going to be part of our legal landscape. And so again, the title of my remarks are The Rule of Law, Not the Rule of Lawyers. I want to do a little bit of walk through history and go back to the period of time when I was in law school, which was about 30 years ago. And in the 1970s, there was still a very wide-ranging debate about this issue of what was then called judicial restraint, or what I would call judicial modesty. And I remember being taught when I was in law school about the 30s and the whole question of the 4 conservative justices who struck down much of the New Deal during the 1930s. And then, of course, there was the Warren Court, which was viewed by conservatives as being excessively liberal and conjuring up wide-ranging legal rights based on political views, which then trumped the political positions of the Congress and most of the American public. And there was a debate about what was the role of the judge. It was, should it be bound to a particular text or a particular set of principles, or did judges have the ability to simply pursue their own personal vision of justice? And when that debate was in full flower, there were really, I think, 4 principal arguments that were made against the idea of judicial immodesty, the idea that judges are free to pursue their own vision of the good life as platonic guardians rather than to tie themselves to some principle of adjudication that is tethered in either constitutional text or some other set of principles that really emerges from our legal documents. The first argument against judicial immodesty was that there is a certain element of dishonesty in interpreting legislative or constitutional words without making an honest effort to ascertain what is the intent, certainly the objective intent of that language. The essence of lawmaking is that we don't allow private discretion or private interpretations of the law. The law has to be enacted and it has to be out there for everybody to see. That was one of the first principles of lawmaking. And when a judge applies a legal text in a way that distorts its intent based on the face of the document or on a fair reading of what is the legislative history, then in a sense you're violating a fundamental principle of honesty in lawmaking, that the law, when passed, has to be open and transparent to everyone. There was also obviously a constitutional problem, a separation of powers problem in judges stepping out of a traditional judicial role, which is the role of being an impartial arbiter, into a legislative policy-making role. There was a competency problem. The competency problem recognizes that judges and lawyers are very good at doing some things. They're good at examining legal language, they're good at understanding the sources of legal principles, but they're not necessarily good at things like running police or school systems or conducting international affairs or foreign policy or running wars. And therefore, when judges begin to get into areas where they're outside of their core competency, when, as was the case in the 1970s, judges issue very broad injunctions that essentially result in them taking over the workings of education departments or police departments or even imagine a military department, that they're operating in an area where their actual skill set does not support wise decision making. There's no argument in favor of having people who don't know what they're doing making decisions. And much as I love my judicial colleagues and as much as I respect judges, I don't know of any judge who is capable of doing everything in every area very well. Not many of them, for example, are brain surgeons, and I wouldn't want to have them telling brain surgeons how to do brain surgery. And the final argument was the legitimacy argument, that if judges overdid their involvement, overstretched and overstepped, they would lose the unique legitimacy, which is at the end of the day, the source of their power. The beauty of the rule of law is that we all accept as a matter of principle that we will abide by the decisions of the judge. But why do we do that? It's not because the judge has the most power. As the Federalist Papers observe, the judiciary is the least dangerous branch. The reason we obey the judges is because they have legitimacy, and from that legitimacy they have authority. But if people were to begin to regard judges as mere political actors, like everybody else, they would rapidly find themselves without legitimacy and therefore without authority. This is exactly what people like Felix Frankfurter or John Marshall Harlan used to worry about. They worried a lot about whether certain issues were political questions, whether deciding things narrowly rather than broadly was the best way to keep the courts out of the business of appearing to be political actors. They spent a lot of time fussing about what appear to be technical principles like standing, ripeness, mootness, which are sometimes viewed as ways for judges to avoid making decisions, but are actually very wise ways of making sure judges only decide that which is necessary as narrowly as possible, and thereby make sure they don't unnecessarily risk their legitimacy by intruding willy-nilly into areas outside of their core competency. Felix Frankfurter, who I think was one of the models that Chief Justice Rehnquist looked to, was very explicit in criticizing the idea that what judges ought to do is pursue their vision of the right society. He described this as dishonest nonsense, and he rejected the idea about judicial decision-making that it should be a matter of determining the wisdom or evil of a law. That was a philosophy of judicial modesty. And it was one also honored by Justice Holmes and by many other of the greatest judges in the history of this country. Felix Frankfurter's law clerk, the famous Alexander Bickel, in his book Morality of Consent, which I'm not sure anybody reads anymore these days, but it was very popular when I was in law school, made the same point. They were very concerned about legitimacy and making sure that judges didn't overstep their bounds for all of the reasons that I've described. Now, what's interesting about this is that during the period of time I was in law school and then in the years I left and went into practice, I think that the debate in this country largely moved in the direction of the Bickel, Frankfurter, even Rehnquist view of judicial modesty. That's not to say that there weren't judges who were, for want of a really poorly described term, liberal or conservative. But everybody essentially accepted the framework that judges had a responsibility to limit themselves and to cabin their decision-making by reference to some enduring principle other than just, let's go out and figure out what will make the great society or the best society. There was disagreement about how one, in fact, anchors oneself in a principle. There were people who argued that you should look at the literal language of, let's say, the Constitution or the statute. Some who believed you could consult contemporaneous sources to understand what the words actually meant. Some argue you can look to legislative history. Some say, like Justice Scalia said, you really can't look to legislative history. But with all these different views, and I think you see them represented on the Supreme Court today, what's remarkable is how much the views had in common. Everybody accepted that there had to be fidelity to a text and to a set of enduring principles. The only question was, what is the most accurate way to reflect that fidelity? And even when there was movement in decision-making in the direction of what some would say was an excessive amount of putting personal opinions into decisions, and I know there's been criticism, for example, in the area of interpreting what cruel and unusual punishment is, that the court tends to look too much to contemporary, quote, polling data as opposed to the actual contemporaneous meaning of the text. Even when the courts have moved in that direction, they have felt obliged to justify themselves and to defend themselves in terms of the notion they are rooting in some notion of the text or some set of principles. So in truth, when I became a judge, this issue did not really seem like it was a burning issue at a high level of abstraction. There were a lot of individual disagreements about how to apply a particular provision, but largely I think people accepted the notion of judicial modesty, and I don't think that it became a particular point of controversy when Justice Roberts advocated it in his confirmation hearings. But although I was tempted to think this particular doctrinal issue was a historical relic, I've started to wonder whether that's true as we come into this new century. I've started to wonder whether it's true in our own country, and I certainly whether it's true in the international legal arena. And let me tell you what I mean. We are facing in the legal profession two dramatic changes in the circumstances that we have before us. One, of course, is what we have faced since September 11th, a battle against an international network of terrorist organizations which are rooted and have safe havens overseas. At one point, they actually were explicitly hosted by the Taliban in Afghanistan. Now they certainly operate in the frontier areas of Pakistan and in some parts of Somalia where they have safe havens. And in dealing with the challenge of these kinds of terrorists, what we have found is we are presented with a host of legal issues that can't easily be answered by deciding whether we are dealing with the criminal justice system or dealing with the military justice system under the traditional laws of war that were developed in an era when you had armies in uniform that met in clearly defined fields of battle. So what that means is we are now confronting judges with uncharted territory. What are the legal principles and doctrines that have to apply when we deal with the issue of terrorism? And whether it's how do we detain people, can we detain them without charging them with criminal offenses, or whether it's the issue of how much judges ought to be involved in determining how we wiretap and what kinds of surveillance are undertaken. This raises a whole lot of new issues. The second thing which is coming up is I think we're going to see some significant changes in economic regulation. And that is, of course, going to present judges with all kinds of new challenges, because I'm willing to bet that if there is a dramatic change in requirements about executive compensation or what kinds of activities people can pursue in the financial sector or in other sectors, we're going to see an uptick in legal challenges to those kinds of regulations and statutes. And there's going to be a brand new invigoration of that set of legal arguments that have to do with the economic power of Congress or the right to protect private property. You see a little bit of that in the Kelo case of a couple of terms ago, which dealt with the issue of takings. So there's actually going to be a lot of new uncharted ground for judges to be exploring. And I think that's going to be a good time to remember about this principle of judicial modesty, because I continue to believe that for all the reasons I've talked about, transparency in lawmaking, separation of powers, competency and legitimacy, judges have to continue to anchor themselves to some principle of judicial modesty when they get involved, particularly in areas of law that are brand new and still in the process of full formation. And what's interesting about judicial modesty is it's actually not conservative or liberal. I've seen in the past that people have a tendency to be more or less enamored of modesty, depending on whether their ox happens to be gored by the left or the right with a particular legal issue. And I think that's a big mistake for judges. I think judges have to be willing to be modest, whether or not they're dealing with a conservative challenge to a law or a liberal challenge to a law. Otherwise, judicial modesty merely becomes a fig leaf for getting to a result rather than a principle that I think is at the very core of the rule of law and why we accept the rule of law. But I think that debate, when it takes place in this country, will actually be pursued along very familiar lines. I think we'll all dust off their law review articles and books from past decades, and we'll debate these concepts in the light of some of the new circumstances that we face. But where I think this debate is most interesting is in the international domain. Increasingly, what we see is international law and international courts, which are not elected by citizens of individual countries, and they're not appointed in the system that we have where someone's nominated and then they're confirmed, where these international courts claim an increasing role to engage in decision-making that is remarkably wide-ranging and has a great deal of impact not only on other countries, but is increasingly likely to have an impact on ourselves. What do I mean by that? Well, for example, in Thailand, 44 current and former government officials representing almost the entire cabinet of the former prime minister are now being tried in the nation's Supreme Court for lottery-related fraud. The prime minister who succeeded the prime minister being tried was removed from office 2 months ago for breaching the Constitution by accepting a monetary payment to appear on a cooking show. Shortly thereafter, an appeals court upheld a 2-year sentence against him for libel. And then, after convicting the first prime minister of vote buying, a court actually dissolved his entire political party. The International Crisis Group, which is a Belgium-based research organization, described what's going on in Thailand as a circumstance where the Thai courts have too much power to undermine an elected government for relatively minor failings. This group added that a balance must be struck between necessary checks on executive power and giving the government enough authority to avoid total paralysis. If you look at Turkey, there was recently a decision by the Supreme Court where by one vote on the court allowed the majority elected political power to continue in power. The reason it came to a vote was because the prosecutor, which was an arm of the court, had essentially sued to dissolve the majority power on the ground that by supporting the right to wear a headscarf in a public university or a public building, the party was violating the strict separation between religion and the state that's part of the Turkish constitution, and therefore the party should be dissolved and should be made illegal. Now, I'm not here to criticize Thai law or Turkish law, But it is quite remarkable to think that courts would be deciding whether political parties would be disqualified because their ideas are inimical to the Constitution. That puts judges in a role that is frankly inconceivable in our country, but it is far beyond what we normally conceive judicial authority to be. It is ultimately giving judges not just the power to apply the rule of law, but it gives them the supreme law, the supreme power. And they begin to become involved in decision-making that is, to my mind, fairly characterized as political. I could use other examples. In Israel, there is a dispute now about and concern about the fact that over the last decade, 4 of the last 5 prime ministers have investigation or criminal proceeding. And one of the columnists in the Jerusalem Post recently observed that Israel has a series of very, very broad and ill-defined laws about political fundraising and what you can do in the political campaign arena and what you can't do. And because the laws are very vague and easily open to interpretation, it's possible for almost any activity to become the subject of a criminal investigation. Now, these don't always result in convictions, but because of the open, textured, and poorly defined boundaries of what's criminal and what's not criminal, once again, the prosecutors, who are separate, they're independent, and the judges wind up having enormous power, because by using very ill-defined and broad criminal concepts, they can delegitimate virtually anybody in power. And we all know, because we're all taught in law school to be creative, that you can take almost any open textured provision and find some way to interpret it to apply to almost any situation. So again, we wind up running the risk that judges and lawyers will determine who is qualified and who is disqualified to lead countries. The most recent example of this kind of very broad view of the role of judges and lawyers is what you see in Spain. There's a judge, Baltasar Garzón, a very well-noted investigative judge, and they have, as you know, an inquisitorial system, who has in the last decade attempted to file charges, and this is in Spain, against the late Chilean president Augusto Pinochet, current Italian Prime Minister Silvio Berlusconi, and former Secretary of State Henry Kissinger. Most recently, he's seeking to investigate the Franco-era murders, even though Franco is dead. And I don't know how you're going to bring him back from beyond the grave. But the point is, the power, this no longer becomes dealing with individual crimes. It becomes essentially the indictment of a whole political philosophy. Now, there are many people who say, this is great. This is the rule of law. This is, it's a terrific opportunity to have the legal imprimatur put on every kind of political activity. But I want you to consider the wisdom of this in terms of judicial legitimacy based on the principles I've articulated earlier. Are the provisions being relied upon here? Are they truly a clear expression of the Constitution that's being invoked? Or if we're dealing with international law, is there anybody who's actually authoritatively expositor, an authoritative expositor of international law? Are we convinced that the source of authority here really does have the consent of the people? Are the judges in question here competent to be judging, for example, what occurs in a wartime situation, what is appropriate military action, what's inappropriate military action, and by the way, not only judging it in their own country, but judging it in other countries? Are the judges really the right people to decide whether a whole political party that has the majority support of a country and a democracy is illegitimate to actually have government because they're willing to tolerate headscarves for Muslims in government buildings? I think these are serious questions that are not, frankly, to my mind, debated in the international arena. Now, I raised this issue about talking about judicial activism and judicial modesty a couple of years ago in an address to the Federalist Society. And when I spoke about it, it was, I was looking around for a topic to talk about. I never talk about legal topics as Secretary of Homeland Security because it's not really part of my domain, and people are more interested in the current threat picture or policy issues involving immigration or things of that sort. But because I was talking to the Federalist Society, which it's sometimes claimed I'm a member of, but I'm actually not a member of, I thought I would talk about a legal issue, and I would talk about this international law question about activism and modesty. And to my surprise, it actually got more attention, public attention, than almost any speech I'd given to that point in time. There was a lot of negative reaction from Europe. How dare I speak about international law and challenge the prevailing idea of international law methodology as an American? It was kind of out of bounds. And then I was surprised that on talk radio, it was the last thing I would have expected to be asked about. And I had talk radio hosts, when I was up there talking about immigration or terrorism, they'd say, well, we read that speech about international law. It was really interesting. So it suggested to me that there was actually something here that I had stumbled into, that people were thinking about a little bit, like what the right role was for judges in the international arena. And then, as I visited with my colleagues overseas, particularly in Europe, my counterparts at Ministries of the Interior and other political leaders who are wrestling with issues like, how do we deal with known terrorists that are in our country illegally, that we are prohibited from deporting by the European Court of Human Rights, or how do we deal with people who are threats to our country that our courts are telling us we can't hold because we're not criminally charging them. And increasingly, these figures in Europe were asking the question, what is the right role of judges? Frankly, some of my counterparts have been criticized for being very blunt in suggesting that judges in Europe are sometimes stepping into areas they don't really fully understand and are not equipped in order to deal with. So it seemed to me that because of developments here and also developments overseas, this is a topic that is well worth thinking about again. Now, I'm not going to give you a prescription for what the right answer is here, but I am going to suggest that this is a matter as to which Americans have a strong vested interest in engaging, not just in our own country, but internationally. And I'll tell you why. The traditional approach to dealing with international law, when we disagree with it, has been for Americans to simply ignore it. And there were a series of cases, and one of them was actually written by Chief Justice Rehnquist, where the International Court of Justice demanded that we halt executions because they didn't comply with international law. And the decisions of our Supreme Court were, thanks but no thanks. Under our Constitution, the states have the authority to make the final judgments. As long as our Constitution is complied with, international law doesn't trump our Constitution. Likewise, when the International Criminal Court was formed, the U.S. not only withdrew any participation in it, but actually entered into agreements with other countries to make sure that our troops would not get caught up in these prosecutions. And of course, back even in the mid-1980s, we declined to submit ourselves to the jurisdiction of the International Court of Justice on certain issues, as we were entitled to do under the treaty. And yet what happened was the International Court said even though we had declined to consent to jurisdiction, they were going to apply it anyway, because they had, based on international customary law, a right to trump our treaty agreement. So what all this is telling me is that we are entering a domain where simply withdrawing from the field of international law is not really an effective strategy or a particularly productive strategy. It's not effective because increasingly in a globalized world, it's hard to withdraw from all of these interactions. It's not productive because actually international law has a great deal to offer to us. It has a lot to offer to us in terms of synchronizing our approach to things like money laundering, environmental problems, international financial regulation. These are areas where if we have firm agreement and clear principles, we can do a lot with international law to make the whole globe safer and sounder. But that only works if we have the confidence that international legal institutions will be disciplined in the way they apply these laws. If you're going to create some kind of an international mechanism to regulate environment, or to deal with the issue of the economy, or to deal with security issues, you've got to have a very high level of confidence that the judges and the arbiters of that set of treaties are going to apply a sense of modesty to what they do and not take it as a blank check to impose on the United States their particular vision of what the good life is. And so I would make the case that this is the best time in the world to start thinking about engaging with the issue of international law, but doing it by actually getting right into the philosophical roots and having the debate about judicial modesty in international fora, and not accepting the view of some Europeans that this is really not our affair, we should just take the edict from the international court and obey it, but rather to get into the intellectual battlefield on the question of what is the right role of judges and what is the right province of international law. What are those areas where international law has real value? Truly global activities, issues that are outside the scope of any one country to regulate. And where are areas that international law really should stay out? Our ability to regulate our own domestic activities, our own domestic legal system, and the way we choose to conduct our trials and we choose to conduct our domestic legal affairs. I think that this is the right time to have that discussion. I believe that the principles of judicial modesty, which I think largely prevail in our own country and which I think are crucial to the respect for judges, that is the foundation of the rule of law, I think those ideas will prevail internationally, because I think people all around the world are fundamentally the same in their understanding of what the value of the rule of law is and what the limitation of the rule of law is. And so I invite you to begin that discussion. I think it's a great area in this 21st century. And I leave you with this thought. If in the end the rule of law is viewed by lawyers and judges as an opportunity to increase their position of power in the world by making it the rule of lawyers, I guarantee you eventually the rule of law will fail. If people begin to perceive judges as political actors who are pursuing political agendas, who cannot or will not justify their activities with respect to a clear principle, who will not self-consciously limit themselves and police the boundaries of their own decision-making to make sure it comports with truly judicial decision-making, then I think we will see the rule of law fail. And so I would argue the best service we can do to promote the rule of law is to make sure we make it clear it is not the rule of lawyers, and to impose the same modesty which Chief Justice Roberts spoke about, which Chief Justice Rehnquist spoke about, which Justice Frankfurter spoke about, which I think is at the very core of our American legal system. Thank you. Yes. I think you'll have to wait for the mic.
Secretary Chertoff, sorry. I have a question about if you're concerned with the capabilities and the rightness of the Spanish judges and people holding accountable Pinochet and Franco's generals, what do you think would work to check those power abuses and to hold accountable those dictators?
Well, I think the question really has to be to consider whether judges can right every wrong. You know, one of the issues that's arisen with respect to international criminal prosecution is sometimes the prosecutor wants to pursue what he or she considers accountability, and yet the consequence of that, and I think we're seeing some of this now in the Sudan, is it may prolong a war. It may wind up actually causing a war. I think our system, we have a very interesting system of the way we deal with prosecution in this country. The framers did not put the responsibility for prosecution in the hands of the judges. They put it in the hands of the executive. That's not well actually appreciated by Europeans, which have a different system. But the wisdom of that is it creates a check and a balance. Both sides have to agree to let a case go forward. There are times when, in the interest of a larger goal, we may decide not to quote, hold someone accountable. I don't think, for example, during World War II, it would have been thought wise to indict Stalin because that might have had an impact on our ability to defeat Hitler. So I think without trying to, on an ad hoc basis, formulate a full-blown judicial philosophy, I think when you are trying to impose your legal principles on a foreign country or foreign government, in the absence of a treaty where the other government agrees that this is appropriate, I really question what the source of authority is to do that. And I think that it takes you down a very dangerous road when you could have judicial warfare, where judges in one country decide they're going to indict public officials in other countries, and then you could have retaliation back and forth. And I think that would be a very, very treacherous and ultimately unsustainable circumstance. Yeah.
Secretary Chertoff, I'm wondering, you talked about fidelity. If we look at democracy as a set of rules established by the authority of a people, and then think about the role that the United States has had historically as a model for democracy, going back even to John Winthrop's A City on a Hill speech, how important does it become for America, hoping to have a leading role in international relations, to maintain the integrity of the laws passed by the people of that democracy? And what role does the executive branch have in maintaining fidelity to that democracy as we move forward?
Well, it was very important. I think that there are two parts to dealing with the rule of law. One is that judges and lawyers have to respect their bounds, and the second is the executive and legislative branch have to respect the rule of law. I know historically there were questions that have arisen about, I think back in the Reagan administration, Attorney General Meese raised the question of whether, if the courts decide something, does the executive branch have an independent authority to decide differently on the issue of the constitutionality of things. I know there are members of Congress who believe that when they pass a law, they get to decide what the law means, because sometimes I have them tell me, well, I wrote the law and this is what it means. And I go, well, actually, that's not the way it works. Once you write it, you've kind of, it's like sending your kid off to college. You don't control it anymore. It's now in the hands of other people. And there I do have to say, and this probably will surprise you, I think actually we have demonstrated fidelity to the law. I know there's a lot of disagreement about positions taken by the Bush administration on certain legal issues, but about this there can be no disagreement. Whether or not the administration agreed with the court decision or not, you've never heard a member of the administration say they wouldn't follow the court decision. And I think that's all you can ask for. Lawyers are always examining legal texts and trying to figure out what does it mean and arguing it means one thing or another thing. And that's what our system is designed to do. What the rule of law boils down to, in my mind, is at the end, when it gets to a court, we abide by the decision. And that is something which this country has always done, with one exception, actually, two exceptions. Andrew Jackson, who told the Supreme Court after the Cherokee case, you make the law, now you go enforce it. And Abraham Lincoln, who defied Chief Justice Taney when Taney said to release someone on habeas, and he just basically said, forget it, I'm not doing it. And other than those two exceptions, which are actually two great presidents, we have always followed the rule of law here, and I think that people don't appreciate that enough. Yes. Oh, I'm sorry, I guess I'm first time.
Is it on? Morning. My name is David Garcia, former member of the Legislative Council of the Law and Automation. But in my opinion, the rule of law has already failed. And you know, that's basically your topic. But I say that it's because even with the reservation that I'm a member of along the Law and Automation along the Southwest, that in fact, when you spoke about treaties, I'm specifically referring to our tribal members who live in the country of Mexico, in the state of Sonora, where even we're trying to address those kinds of issues when in fact it is the attorneys who mainly have changed the way that the politics is within the United States and Mexico. So again, that was just my opinion that I wanted to share with you, because you are talking about the rule of law, when even there's a law review that even the Supreme Justices went and changed a lot of things because of the politics that was in the United States addressing tribal governments, if you will. So thank you.
Yes, back there.
Isn't there a certain risk with the overuse of judicial modesty as almost a backdoor form of activism if it's inconsistently applied, courts refusing to hear cases because of these doctrines you talked about, political question, et cetera? For example, The Real ID Act gives your office the authority to waive federal and state laws in order to build fencing along the border. The court denied the court did not hear any questions as far as that case goes, and so to a certain extent, do you think that, and people interpret that as kind of the court taking a pass on issues that maybe should be decided and in favor of their personal political beliefs?
I have to agree with the first general proposition. I don't think modesty, if you have a duty to decide something, I don't think modesty allows you to evade that duty. I disagree with your characterization of the decisions in the Real ID Act. Every court that looked at it evaluated whether the act was constitutional, and so they decided the case. And you might not agree with the outcome, although I think it was actually quite predictable based on the precedent. But that was not an example of a duty, of avoidance of a duty. It was deference to Congress, particularly as it relates to a statute, because no one argued that the Real ID Act gave me as a secretary the right to disregard the Constitution. But Congress did have the right to say, as the courts found, that we can trump prior laws in the service of achieving a particular result.
Secretary Chertoff, you've mentioned that international law is going to have, as time goes forward, is going to have more of an effect on U.S. law. I wonder if you could comment on how that comports with the Constitution statement that it shall be the supreme law of the land. How can that be so when the jurisprudence of other countries is affecting, in effect, changing ours?
Well, actually, that's kind of my point. I think that international law will affect us because when we deal in the international arena, we're going to need to deal with other countries, and that means, like, if we're dealing with global trade or global security, we're going to need to reach agreements. And that means it's important to be sure that when we reach agreements, we have confidence that they'll be interpreted in an appropriate way and not be used to do what's inappropriate, which is to start to get into our domestic affairs. And that was precisely the point I was making, that what I don't think is proper, and it comes back to the earlier point about the judge, what I don't think is proper is for international law to assert that it has a right to deal with a purely domestic matter. It comes up with a death penalty. It's quite clear that around the world there's a belief the death penalty is wrong and out of bounds. And the International Court of Justice has repeatedly tried to intervene to stop executions. Now, I don't know whether you agree or disagree with the death penalty, but as I understand our Constitution, the supreme law of the land is the Constitution. And no treaty can abridge the Constitution. And the Constitution gives certain authorities to the states. And as long as the states carry out those authorities consistent with the Bill of Rights, the federal government has no ability telling them what they can and can't do. That's federalism. So that's an area where I think international law oversteps. And that's an area where we need to say to international lawyers and judges, your effort to try to micromanage our legal system is not an appropriate area. That's an immodest extension of international law. And I'm glad you raised that, because to me that's the nub of the issue. In my view, we rightly push back when people try to argue international law is a basis to trump our domestic political processes. On the other hand, when we're dealing with truly global issues like how do you make sure that everybody's global cargo is handled in the same way, or how do we make sure that global financial activities don't foster money laundering, there we're not dealing with purely domestic matters, and there we do need to be able to have international agreements. So properly disciplined and modest, international law can be helpful to us. But what we've unfortunately seen again and again, this is why I want to get in this debate, is an effort by some people to use international law as a wedge into actually telling Americans how they ought to operate our domestic government. And that, I think, is about as immodest as you can possibly get.
Secretary Chertoff, I'd like to ask you a question relating to your current position and responsibilities. It's sparked by an article that was in our local newspaper this morning about a brilliant young violinist from Singapore who was invited to play with the local chamber music society but was unable to get a visa until they went through enormous contortions. And in fact, in the interview, she talked about how she could fly anywhere in Europe, anywhere in Asia, get off the plane and play a concert. It seems to me this is exemplary of what many people feel is a kind of skewing of the costs and benefits of security, which is a benefit against the cost that it is imposed upon both some of us who go on airplanes and can't carry toothpaste tubes, or visa laws or whatever. And I'm just wondering if you would comment on that.
I don't know the individual case, but I will surprise you by saying it is often the case that when you hear about an artist who is denied a visa, it has nothing to do with security. It may surprise you to learn that under the visa rules which Congress has passed, in order to get a visa to come in and work as an artist, you have to demonstrate a very high standard of skill. And although I can't say this for a fact, I suspect that somewhere along the line, lobbyists for domestic performers got Congress to make it hard for foreign performers to come in. I don't personally happen to think that's a good reason to keep people out. I doubt very much it's a security issue. A lot of times we get blamed for visa policies and trade policies that have nothing to do with security, but are they fly under cover of what we do to achieve what I would call protectionism. On the issue of toothpaste, and of course we hope we can get the technology in place, and I think it may happen in the next year or so, to be able to relax that rule on liquids. But here I think I do take responsibility for this. After the August 2006 airline plot, it became clear to us that terrorists had figured out a way to construct chemical explosives, powerful chemical explosives that could bring down an airliner and put them in what appear to be sealed containers so that you wouldn't be something that you could readily tell might have been tampered with. And so we had to deal with the fact that we now knew that there was a technique out there, a capability, and an intent to use this to take down airliners. And we did a lot of research, and we came up with a solution that we thought allowed some ability for people to carry liquids on, but at a quantity level that would make it very difficult to use it to construct a bomb out of. And some people say we're too light, we should ban all liquids, and some say we shouldn't do any. But if we were not to do this, then, to be honest, we'd be taking a chance. It would just be a question of whether you were lucky or unlucky enough to be on the flight where someone got on with a liquid explosive. But this was a pretty easy case because we didn't need to imagine that people might do this. We knew they actually had tried to do it. And that a lot of our security measures are driven by actual experiences or things that are either public or not public that we have learned about what terrorists are planning to do.
I think we have time for 2 more questions.
Okay, over there.
Secretary Chertoff, do you think we've already begun down the path to seeing judges, especially Supreme Court justices, as political actors, given what happens in the nomination and confirmation process and in the politicization of their decisions and their political views?
Well, the nomination process definitely has been unhelpful because it conveys the impression sometimes that what members of Congress are trying to do is get commitments in advance on votes like they would, for candidates for public office. And I think someone recently proposed, at full disclosure, I know both Chief Justice Roberts and Justice Alito. In fact, I was Justice Alito's first assistant U.S. attorney. When he was U.S. attorney, I was his colleague on the court. So, full disclosure, someone suggested that they didn't like some votes that either the Chief Justice or Justice Alito rendered. Maybe they should be called back up to be asked whether they had lied in their confirmation hearings. So that's clearly a bad thing, and we ought to get out of it. Another bad thing is the press tendency to tell you who appointed the judge or the justice deciding. And I have to tell you from my experience as a lawyer and as a judge, that has zero impact on decision-making. And it is a shorthand, dare I say, intellectually lazy way of some observers to kind of characterize someone in terms of whether their decision was expected or unexpected. I think that's really unhelpful. What I think is the most important fact, though, is what the judges do. If in writing opinions, and in making decisions, the judges demonstrate that they are behaving in a way that is disciplined, that appeals to principles, then I think that they're secure. I have to say, I've never seen this on the Supreme Court, and then I have to, again, go back to my time as a Court of Appeals judge and also as a lawyer. I've occasionally seen, particularly district judges who sit by themselves, write opinions that look a lot like, I'm going to ventilate my personal views and tell you what I think about the world. And although they ultimately decide the case based on the law, that sharing of your political feelings, I think also raises troubling questions about whether you're sending the wrong message to the public about what the role of a judge is. One more.
First of all, I would just like to say thank you very much for taking the time to make the trip here and speaking to us. And second of all, I sort of want to build on Sherry's question earlier about fidelity to democratic law. To what extent do you think, Secretary, that courts get some of their legitimacy from fidelity to popular sentiment?
Well, that's an interesting question. You know, the great fear has always been that judges would play to the gallery, whether it be the press or more broadly. I actually think, certainly at the federal level, judges, I've never seen a judge do that. I think judges do take very seriously that independence, you get independence not because it's just a gift, but because you're supposed to exercise it. I will say, and I know this is a matter that's near and dear to Justice O'Connor, so it's fitting for me to conclude on this, there is a concern on those states where you have elected judges, where you have very vigorous and expensive campaigns where the lawyers contribute, that you do run a risk. At a minimum, a public perception that judges are simply political actors and they're going to decide in favor of their campaign people. And you may even in some cases actually affect behavior. And I think that's one of the reasons why I know Justice O'Connor is, she has a project. Full disclosure, my wife works with her on this, so I don't want anyone to say I'm shilling without putting it out there. But she's working very hard to have on this issue of particularly how you deal with the election problem so as not to delegitimate. And unfortunately, some of the people that you would like to see join in trying to correct this problem of unrestrained campaign contributions in judicial elections actually have supported this because they're trying to maneuver to see if they can get an advantage. And I've seen it from both the, quote, liberal trial lawyer side, and candidly, I've seen it from the, quote, conservative business side. And so let me end with saying this. If you believe in independence and modesty, you've got to be faithful to the principle whether you're left or right and whether you win or lose. If it becomes simply an argument for people who are, on one side of a political issue or another to get their way, then it's really a hopeless circumstance. So I think that this is really, it comes down in the end to us. Do we want judges who are modest, fair, and impartial? And if so, we've got to support that. Thank you very much.